Constitutional Remedies and Writs. This event is jointly organized by the Law Audience Journal and Joint Jurist Journal. With us today, we also have Advocate Varun Kumar sir, who is the founder of Law Audience Journal. I welcome you, Varun sir, and thank you for this wonderful collaboration. Before we start the session, it is my absolute privilege to introduce our main speaker for today, Advocate Rahul Tiwari sir. Sir is practicing before the Delhi High Court and the District Court in Gurugram. Along with his practice, he has written more than 20 research papers and published several research works. He is also pursuing his LLM in IT laws. Sir also work as an panel counsel in many organizations. He teaches law as a visiting faculty at Gurugram University and as an educator at the Trial Tactics Litigation Academy in Delhi. He has a great experience in civil, criminal, and especially in a family matrimonial disputes and a child custody matters. We also excited to share that he is now joining India's leading coaching institute, PW PhysicsWallah, where he will be teaching civil and criminal drafting to aspiring lawyers. Varun sir and I feel very lucky to have you such an expert speaker with us today to teach us about it. And before we start the session, I have a few important instructions to all the participants. Please do not disturb the speaker during the webinar. If you have any questions or queries, we will take all of them at the end of the session. And without taking more time, I now request to the Advocate Rahul Tiwari sir to start the session. Over to you, sir.
1 minute. Uh, I'm logging from other device also, so I can share the screen. Okay, I want to share few PDFs so that the participants can see and can gain not just the theoretical knowledge but also the practical insights. Just 2 minutes. Okay.
Yes, sir. Definitely, sir.
So hello everyone. My name I've sent the invite through email. I'm from uh, my PC also. Now, so hello everyone, this is Advocate Rahul Tiwari, and thank you so much for taking out time and especially taking out time on Sunday's morning, which was free for everyone, but still everyone has joined and they are giving their time. I'm really thankful for that, and I'll try my best that everyone after the session can gain some practical insight from me. Okay, just give me 1 minute. So today's topic is regarding the writ petition, and I'm sure most of you are law student and or recently graduated student. Now, regarding the writ petition, when we start, just a second, asking the name. Please let me in. Yes, yes. Okay. Yes, yes, yes. Now 50 participants are there, as I can see. And where is the option? Ah, yeah. Here is the option. Yes. Can you see this on the screen, everyone?
Yes, sir.
Hmm?
Yes, it is visible.
Now, so this journey basically, let me give you a small introduction about myself. I graduated in 2019, and because of my research skill, I was given a job by, I secured my first job in the Supreme Court itself under an advocate on record who is now designated senior advocate M.R. Samshad sir in Babri Masjid demolition case. Okay, so it actually, and that was my research skill which actually helped me now, and that actually helped me to gaining the practical insight that how basically the court works, how the constitutional law should be interpreted, how if your uh, fundamental rights are violated, how you have to approach the court. So that actually gave me a particular boost. And although I have appeared on various cases before Supreme Court of India, High Court, and Lower Court, but this particular case marks as my biggest achievement, okay, of my legal career of last 7 years. Now I'll tell you how. So I'll explain during the course of this webinar. Now, before we start, let me just do away with few basic formalities that, as we know, that this webinar is on writ petition and the constitutional remedies. Now, before the start, understand this thing. Like suppose this is a court. All the courts have got two sides. Okay, two sides. One is the original side, and one is the appellate side. High Court, and I'm talking about High Court and Supreme Court. So High Court and Supreme Court, both of them will have two sides. Original side, where you can approach the court directly. Okay. And one is the appellate side, where you approach the court by the way of appeal only. Means you cannot approach that court for that matter directly, but you can only file the appeal. Like suppose if a matter is decided in the lower court, okay, in the magistrate court, the appeal is filed in the sessions court. Then if it is decided and you are not satisfied with the decision in the sessions court, then you file an appeal in the high court. So that side is called appellate side. Okay, appellate side covers both the jurisdiction, criminal jurisdiction, criminal appellate jurisdiction, okay, for to look into the criminal appeal, and civil appellate jurisdiction to look into the civil appeal. I hope this part is clear with everyone. I'm talking about just High Court as of now. So give me thumbs up. Everyone understood? Now, where most of the student gets confused. Now, if the appeal is pending, is pending and the High Court decides the matter, and High Court says that, okay, I'll give you the certificate to appeal, go file appeal in the Supreme Court. Then also in the Supreme Court, you have got two sides, original side and appellate side. Then again, in the appellate side only, if you have got certificate to appeal, you will file a, like suppose it's a criminal case. Let's suppose it's a bail matter. Okay. In bail matter, you have filed a bail application under section 439 of CRPC, or in the BNSS under section 483 of BNSS. Okay. The bail is dismissed. Okay. Then what will happen? Let's take about a criminal trial. Let's suppose a criminal trial has been pending. The High Court decides that, okay, 10 years imprisonment is given. Now, if you want to appeal against that order, High Court will give you a certificate to appeal. Let's go and file a criminal appeal in the Supreme Court. Then you will file a criminal appeal in the Supreme Court. Okay. You have got a relevant article for that also. Okay. Now, if a bail matter is decided, if a bail is dismissed, or the High Court says, no, I'm not giving you any certificate to appeal, my decision is final. Then also, please keep this thing in mind. Then also, you will file. In that case, when you don't get a certificate to appeal, then you file a special leave petition in the appellate side under Article 136. That is called a special leave petition. And more, whenever I judge moot court competitions, that moot court competition, I have just close to 30 moot court competition. There also people gets confused between a PIL and an SLP. So SLP is what? If a matter is decided by the High Court and the High Court does not give a certificate to appeal, then only you file a special leave petition. Okay, please start making a note for that. Then only you file a special leave petition in the Supreme Court of India under Article 136. Is this clear or not? That is not a PIL. Everyone, please give me thumbs up. Understood, everyone? Yes, sir. Ashmi Sharma has raised the hand. Please tell me. Ashmi, unmute yourself and ask your doubt.
Understood, sir. I was just trying to react. By mistake, I raised them.
Okay, no issues, no issues. Now, the appellate side is clear. Now, original side. Whenever you feel your fundamental rights are violated, then the Constitution of India has given you a tool to protect your fundamental right. Please make a note of it. To protect your fundamental right and to enforce your fundamental right if it is not being enforced. Okay? So if your fundamental rights is violated or your fundamental rights are not being enforced, then what will happen? Then you have the right to file a writ petition. And when you file a writ petition, okay, in the High Court, you file a writ petition under Article 226 of Indian Constitution. And if you file a writ petition in the Supreme Court of India, you file under Article 32 of Indian Constitution. Okay? Because see, I'm teaching all these things in small parts so that it gets cleared, so that the confusion does not remain. So is this thing clear or not? Everyone. Okay? In High Court, you file a writ petition under Article 226. In Supreme Court, you file a writ petition under Article 32. Now, always remember, my dear friends, always remember this thing. High Court has a bigger jurisdiction for writ petition. Remember this thing. You can file a writ petition in Supreme Court only if the fundamental rights are being violated. But the High Court, for fundamental rights, if they are violated, you can file a writ petition. Or if your any legal rights are violated, any other rights are violated, for that also, you can file a writ petition in this High Court, in any High Court which has the jurisdiction over that particular issue. Okay? But in Supreme Court, only for the fundamental right. Now, is this part clear or not? Give me thumbs up. Clear? Very good. Now, moving forward. Now, people will ask me, sir, what is a PIL? PIL means it started with Justice P.N. Bhagwati in 1970s, basically. PIL means public interest litigation. You file PIL on behalf of other people who are poor, downtrodden, and who cannot approach the court themselves, and their fundamental rights are being violated. So if there is a poor person, if a manual scavenger, his fundamental, or a sweeper, or a very poor person who has got no remedy, no money, nothing, and his fundamental rights are being violated, then you will file a PIL on their behalf. So PIL are filed as a writ petition in High Court under 226 and in Supreme Court under 32. It is different from SLP. SLP is filed against the order of High Court if you have not got the certificate of to appeal under Article 136. But PIL is filed only for the social cause and for the people who cannot approach the court directly. If you are filing a PIL in Supreme Court, Article 32. If you are filing a PIL in the High Court, Article 226. Is this thing clear? Are these things clear or not? I hope before moving forward, at least two sides of the constitutional courts are cleared with you, and the difference between a PIL and an SLP is clear with everyone. Is everyone clear now? Now, so whenever a writ petition is filed on the ground that someone's fundamental rights are being violated, what happened in that case? Basically, Supreme Court or the High Court, in the court in which the PL has been filed, they try to interpret Article 21 along with the Article 14, 16 and 19, that on what, and 25, if it is a religious matter, that on what ground the fundamental rights are being violated and what remedy can be given to the applicant. Okay. So basically, that court, that constitutional court, interprets the Article 21. And for that interpretation, before I move forward, it is very essential because when you will start doing the writ petitions, you should know the rules of interpretation. Basically, when you do the writ petition, so interpretation के rules आपको पता होने चाहिए. So what are the rules of interpretation? There are 3 rules of interpretation. Always remember this thing. Okay. First, and please listen to me very carefully. First, and then I will start with my cases, and then on what landmark cases the writ has been secured. And you can ask me the question that on what basis, like if someone right has been violated, can he file a PIL or a criminal complaint? We will do the discussion later. Now, there are 3 types of rules of interpretation. First is the strict rule of interpretation, means whatever is written in the law has to be, whatever is written in the law, it has to be interpreted in the same manner. Okay? Though no one can apply their mind. Like, for example, for taxation, if on any particular amount 30% tax is being imposed, then it has to be 30%. Okay? There cannot be any if and but. It cannot be 30.1% and it cannot be 29.9%. That is called strict rule of interpretation. Then, although second rule is golden rule, but I'll come on the last. Second is the interpretation of mischief. It means that whenever the law is not clear or there is a substantial gap in the interpretation and institution try to interpret that particular thing or that particular law themselves. Okay, that is called interpretation of mischief. I'll give you a very prime example. Article 19, subclause 1, what does clause 1, subclause A, what does it say? Freedom of speech and expression. Means you have freedom of speech and expression. But subclause 2 says what? That you have freedom of speech and expression. Now listen to me where this is important. You have freedom of speech and expression. Okay, abhivyakta ki azadi. But say at the same time, clause 2, what does it say? That all the fundamental rights are subject to reasonable restriction. Reasonable. It is not written restriction. It is called reasonable restriction, that you cannot violate someone's fundamental right, or you cannot defame someone. It cannot be immoral. It cannot be against public order. It cannot be indecent. It cannot ruin the foreign relation of our country. It should not violate the sovereignty of the country. Okay, if you are not doing this, feel free to enjoy your fundamental right. So what is your fundamental right? You have freedom of speech and expression, but at the same point of time, subsection 2 says what? Defamation. That you cannot defame a person, and defamation is what? Defamation is punishable offense. And section 356 of Bharatiya Nyaya Sanhita and section 499 of IPC, that you cannot defame someone. आप बोलिए जो बोलना है, but आपके कहने से किसी को hurt नहीं होना चाहिए, कोई बदनाम नहीं होना चाहिए. But when you see the exception number 4 in that section 499 of IPC or in BNS section 356, it says the media has the right to show whatever is happening in the court, to report the court proceedings. But what does the media do? Like suppose if it's a murder case, accused is arrested, accused is brought to the court, accused applied for the bail is rejected, the accused is sent to the police custody for 2 days. Let's take an example. So media should have been reported only this much, no? This is called court proceeding, but because the law is unclear over there, what does the media misinterpret? And it uses the interpretation of mischief. Media starts conducting the media trial. Like suppose the accused name is Rohan Kumar. Okay. So what does the media do? He'll publish the photograph, name of the person across all the channels. Okay. His reputation is now ruined. Okay. And what they will say that Rohan Kumar, he is the Khuni Darinda. He was arrested and he was brought before the court. He was crying. He was wearing this kind of dress. And we are waiting that when the court will declare him guilty. Now the trial will take place for 5 years and the media has declared him already guilty. That is called media trial. Always remember one thing. Media trial is unconstitutional. In MP Lohia versus State of West Bengal 2005, Supreme Court has clearly said that all forms of media trial are unconstitutional. Simple. So that is called interpretation of mischief. Is this part clear or not? Give me thumbs up. Is this part interpretation of mischief किसे कहते हैं? समझ में आ गया? Good. Now the third rule is golden rule of interpretation. So whenever you file a writ petition, the Supreme Court or the High Court, in the court where the writ petition is being filed, the court uses the golden rule of interpretation. And what does the golden rule of interpretation? It means that at what stretch it can be interpreted in the same wavelength. Like for example, when the Constitution was drafted, Article 21, what does it say? Article 21 says that you have right to life and liberty, which means that any life without dignity and liberty is just a mere animal existence. So every person is entitled to a dignified life. Only then he will called a human being. एक इंसान जिसको एक dignified life मिल रही है, उसी को तो आप एक इंसान कहेंगे ना. जिसको कोई डिग्निटी ही नहीं मिल रही तो उसको कुछ नहीं मिलेगा. Biggest example of PIL and enforcement of writ petition and using a constitutional remedies is the famous if anyone can recollect his name, the environmentalist. Right to clean environment is your fundamental right. The Taj Trapezium case, the Bhopal gas case, where that advocate filed so many PILs in the High Court and he ensured that the environment remained clean. Okay. Very recently, when a retired judge filed a PIL in the Supreme Court to enforce that whether right to privacy is a fundamental right or not, and in 2017, MC Mehta, yes, Sejal Yadav, thank you. MC Mehta versus Union of India. Okay. MC Mehta versus Union of India. It was held, the constitutional, the courts interpreted that right to environment, clean environment is your fundamental right. In Puttaswamy, KS Puttaswamy versus Union of India 2017, the court held that right to privacy is a fundamental right. A prime example, when a person was killed in a police custody, the Nilabati Behera, the woman whose son was killed, she wrote a letter to Supreme Court and that letter was converted into a PIL. And court was held that custodial violence violates the fundamental rights of an individual. Very recently, when the government was making a demolition drive across the country, okay, this partisan across the country without conducting the trial, that if a person is accused, the bulldozer used to come at home and no, not Arnesh Kumar. Arnesh Kumar was a different case. Now, what used to happen? The bulldozer used to come and it used to demolish the drive. It used to demolish the house. Okay. Then again, the writ petition was filed in the form of PIL. A PIL was filed in the form of writ petition. And the Supreme Court stayed all the demolition activities without conducting a trial. So all these matters, I have told you, they are big matters. They are matters. They are matters which gained national recognition. Okay, yes, Vaibhav, please. And I'll request that please raise hand only when I give you time to ask your queries. But yeah, but as you have raised your hand, please ask. Vaibhav, I'm waiting. Okay, no problem. Now, what are the golden rule of interpretation? Like right to health is your fundamental right. Exception of Varsha Dubey, exception for defamation. Exception 4 of section 499. It is clearly written. Okay, exception 4 of section 499, read in the Bare Act. Okay. Now, as I've told you about the big cases, like right to health is a fundamental right. Again, the product of golden rule of interpretation. It was not the part of the original draft. Right to education is your fundamental right. Again, it was the product of golden rule of interpretation that it is a part of Article 21. So if someone has filed that his right to education is being violated, okay, he will file a writ petition and he will get his right enforced. Okay. Now, how many types of writ petition are there? 5. First is the habeas corpus writ petition. It means it says what? To produce a body, or you may have a body. Means if a person is being illegally detained and nowhere is to be found, one can always file a habeas corpus writ petition. I was part of a team where my colleague had filed a habeas corpus writ petition, and it was basically a quite funny one. Actually, there were a couple who wanted to get married to each other, and both of them were like 19 or 20 years old, consenting adults. Now, what happened that the girl's parents had locked that person in their house. Okay, that she will not go anywhere. Then they'll say that have you decided what will happen? So we first filed the missing complaint, and then nothing happened. Again, no police action. Then we were like, let's file a habeas corpus writ petition. We filed a habeas corpus writ petition. The girl was produced in the court, but as the luck have it, the girl said that no, she's forcing himself upon me. I don't want to get married to her. I mean, if that would have been succeeded, again, I would have made a good name for myself. But but after that, once the case was dismissed, we took at least 30 to 40 minutes to console that guy that you have got to your whole life ahead, forget that woman and proceed with your life. It happens. So it's fine. So habeas corpus writ petition. Second one, if you are, it's in fact for me it is the most important writ petition. If you are fighting against public authority, which is called writ of mandamus. Writ of mandamus means we command. It is to secure a public performance. Sorry, to secure performance of public authority. And I'll come to that with my PIL now. Then writ of certiorari means to be certified means it means that the court has the right to quash the order already passed by the inferior court. Means if the inferior court has passed an order, we can always file a writ of certiorari. Okay, if the order is illegal. Okay, and I'll start giving you the example, and I'll dictate you the case laws also. Then the writ of prohibition means to prohibit inferior courts from continuing a proceedings. Quo warranto, what is the authority to restrain a person from holding any particular authority? Now, let's come to some real life example. Now, what happened with me? This is clear now. Okay, page number 2. So even after gaining 7 years of experience, and I guess speaking on close to more than 60 webinars, the habit of making notes before the webinar then never goes away. Okay, so it clearly means that irrespective of how many years of experience you gain in this field, it will never be enough. You have to keep updating yourself. Now, what happened? I passed my LLB in 2019. LLM, 1 year LLM, cleared in 2020. Then I planned, I practiced, and then there was a COVID period. Then I was planning that okay, PhD should also be done. Okay. Then recently, IIT Kharagpur had IIT Kharagpur basically they gave a notification. Means you all know that IIT Kharagpur also has a law school which is called Rajiv Gandhi School of Intellectual Property Law, RGSOIPL. Okay, it's a very famous law school, and it's a very prestigious one also. And they conduct the PhD also. Okay. Now what happens? They had a very strange rule that if you want to take admission in the PhD, you must have 2 years LLM. Now, I had 1 year LLM, so I politely asked the dean through mail that, sir, I have a 1 year LLM which I have done from a regular degree. Means you should always you should know that the no law degree can be done through distance mode. Your BLLB, LLB, BBLLB, LLM, nothing can be done through distance mode. It has to be done through regular course only. So I requested that, sir, I have done my regular LLM uh, from from KR Mangalam University. So I wish to take admission in the RJSOIPL, but I cannot fill the form because it says that you must have 2 years LLM. So am I eligible to take admission? He simply said only one word. He wrote in the mail that, okay, not even that, dear Rahul and everything, that as per our policy you're not eligible or everything. Thanks, Dean, School of Law, RGSOIPL, IIT Kharagpur, nothing. He just replied with one word, no. And I was like, one of my senior had told me, he's a criminal practitioner, and he said a very famous line, वो advocate ही क्या जिसमें ego ना हो. Okay, that certain amount of narcissism or a certain amount of ego has to be there, that, okay, you cannot pinch me over. I was like, no. First of all, it got hurt over here. And then I was like, okay, admission nahi denge, but on what ground? Just because I have got 1 year LLM. Then I did a bit of research that how many types of LLM degree we have in India. Now, this is the interesting part. So I found out we have got 3 types of LLM degree in India. And India is the only country which gives you 3 types of LLM. Now, what is the history? That traditionally, post-independence, we had 2 years LLM degree, regular basis, 2 years LLM degree. And even till today, all the government universities, whether it is Delhi University, Bharati Vidyapeeth also, Pune University, Bombay University of Bombay, or Banaras Hindu University, they still give you 2 years LLM degree. Okay. Now, this concept changed in the West. USA, they give you 1 year LLM degree. Harvard, Stanford, everywhere. Cornell, you go anywhere, you'll get 1 year LLM degree. Europe, Oxford, Harvard, London, or in Germany, everywhere they give you 1 year LLM degree. But in India, they were still continuing the age-old practice of 2 years LLM degree. Then Bar Council of India decided that we must adapt and we must ensure that because we must ensure that we get a good number of law graduate in the academics also. And if we reduce the period of LLM to 1 year as our Western counterpart, it will be better. Okay, it will be better. Why? Because after 1 year of 1 year of LLM degree, they can come to PhD or they can start teaching. That was the reason, and that's why they decided in 2015 to introduce 1 year LLM degree. And in the UGC notification also, they said that both the degree can run concurrently in the institution, first of all, and both the degree, UGC clearly said both the degree, 1 year LLM degree is equivalent to 2 years LLM degree on every aspect, whether you want to go for a job or you want to go for a PhD admission, everywhere you can go for 1 year LLM degree. IIT Kharagpur used to give 2 years LLM degree. Okay, early and still even till today they are offering 2 years LLM degree. Then after 2015, what happened? That all the NLUs who used to give 2 years LLM degree, they switched to 1 year LLM degree. Okay, this representation I sent in 2021, 6 years after that notification. Now And as of now, 80% of the law school in India, they give 1 year LLM degree. Okay. Now, third type of LLM, and I don't want to get confused, but you should know it is called executive LLM. It is basically a distance LLM which is given by a lot of NLUs that the classes are conducted in the evening or online, and you have to just give an exam and you'll get LLM Pro or LLM Executive. And even in the brochure they write that this is just for this degree is the master's degree is just given for the knowledge enhancement. It cannot be considered as equivalent to 1 year LLM degree, and it cannot be considered equivalent or for any teaching eligibility. That part is clear. But I had a regular LLM degree, 1 year LLM degree, regular, and I questioned that what if someone who has done his LLB from Oxford University and has done LLM from Harvard University, and he comes to the IIT Kharagpur, he is not eligible. Why? Because he has got 1 year LLM degree. It was not making any sense. And I have my right to education. I researched and I found out few judgments also, which says that right to take admission in top institution on merit is also a fundamental right. Means I cannot be denied admission in the any top institution if I clear an entrance exam. But here I was not allowed to sit for the exam. So what happened? I contacted few of my seniors that how do we draft these writ petition and everything, and they said it's not that a big deal. Just like legal notice, first send a legal representation. Okay, send a legal representation. Once the legal representation is sent, if they do not change it, and the legal representation has to be sent to the governor also. Okay, and then if they don't take any action, then you file a writ petition. But sending representation is mandatory. I was like, fine. So I sent a representation. I filed a case also. I was quite late, but still I was given a good hearing. And as I told you, that was a COVID period. I had relocated to Indore at that time, and there was a confusion between online hearing and offline hearing in Calcutta High Court. So I said that I'll appear online on the next date of hearing, but they switched to offline hearing, and then my case was dismissed at that point of time because of dismissal of default, because of non-appearance. Fine, no issues. But I waited that now I have got everything in my hand, all the evidence. Then I got married, life went on. Then in 2015, I decided that, okay, 1 year LLM degree again. Now this time I'm going to secure justice, if not for me, but for other people. I sent the legal representation. And before that, I had filed an RTI also in the IIT Kharagpur, that on what ground, that first I filed an RTI and I asked that are 1 year LM degree holder eligible to take admission? They said yes, but they should be net qualified. Then I filed in another RTI. On what ground? No reply. Then I filed an RTI that are 2 year LM degree holder eligible to take admission? He said yes, fine. In this notice, I clearly mentioned that your RTI replies are contradictory to each other. And finally, this is my achievement, although I didn't have to file the case. Guys, see this. Response to your legal representation, eligibility criteria for PhD admission in law. Ranjit Kumar, you can see, admin, IIT Kharagpur. Okay. And see what is written. I forced IIT Kharagpur to change their eligibility criteria, because in my representation, I clearly written that if you don't change your eligibility criteria, and if you don't allow candidates with 1 year of LM degree, first thing I'm going to do is I'm going to file the writ petition. I will take a stay in your examination, and your examination will not get conducted. Finally, they have understood, and this you can see. With reference to your email regarding eligibility criteria, I've been directed to inform you that Institute has recently uploaded the latest information brochure for PhD admission, amendum, on the Institute website under admission section. As per this amendum means they have added that 1 year LM degree has been included as eligible qualification for the admission in PhD law program for upcoming spring season. And this marks as my biggest achievement. कि आपको एडमिशन तो देना पड़ेगा, और एडमिशन नहीं देना है, एटलीस्ट उनको एंट्रेंस में बैठने का राइट देना पड़ेगा. Means if someone has completed 5 years of LLB degree anywhere from India, then he has, let's take an example, he has done his LM from NLS Bangalore. He gives CLAT PG, he secures All India rank 1, he completes his LLM degree from NLS Bangalore, from the #1 institute of India, but he is not eligible to take admission in the PhD program because he has got 1-year degree, the 1-year LLM degree. They were not making sense themselves, so I made them think logically. And this is the power of writ petition, and this is the power if the advocate has got proper knowledge and he fights for the rights, for the fundamental rights for himself and for the others. IIT, the dream institute for every Indian, I made them change their eligibility criteria. And this time I didn't have to go to the court. And that is why I said that irrespective of all the cases I have done as of now, but this marks as my biggest achievement. Okay. And this is also what you can do. Now, another screen, see how the representation was given. Share. Yes. Now the brochure, how you identify that, how you have to file the case. The brochure is published. You read the brochure and you said, yeah, you're not eligible. This is wrong. My fundamental right is being violated. You'll send the legal representation. See, dated 13/2/2025 to the Dean, subject representative regarding the information brochure, respected Dean. I, Advocate Rahul Tiwari, age 32, this. I am raising objection regarding the, let me zoom it. Your information brochure for PhD admission, and the point he says LLM 2 years program, either after 5 years of integrated LLB or 3 years degree program. And I said that our candidate, and then I said I had filed the RTI also. In RTI, you are saying this, that. You explain all the criteria, and then how you basically write is from this point. Further, such action taken by prestigious is a national which is vested with constitutional liberty. It shall be under the purview of Indian Constitution. Means you have to first explain that whatever you are doing is first of all illegal. It is against the purview of Part 3 of the Indian Constitution. It is violating the natural justice and the natural fundamental rights. You have to mention these words again and again. It was violating the fundamental rights of the individual. And then you have to use this word also, Wednesbury principle, in the petition. Okay, and then I hereby directing you that after you receive the legal representation, please change it within 7 days. And see, copy to Governor of West Bengal. Whenever you are filing a writ petition in particular High Court, a copy has to be sent to the governor of that particular state. And because law is involved, one copy has to be sent to the Secretary of Bar Council of India and Under Secretary of UGC. One copy has to be sent there. And all these, government will not be made a party. The state will become a party. So state of West Bengal become a party. Party 1 is IIT Kharagpur. Party 2 is State of West Bengal. Party 3 is Bar Council of India. Party 4 is UGC. So whenever you will file a writ petition, a copy of your writ will be sent to all four. All four of them will send their legal representative in the court. And then the argument will start. And for that, how it happens, I'll explain you that also. And these are the annexures. See, I had filed the RTI. Our candidate with 1 year degree eligible, 1 year degree with net qualified. Then I filed another RTI. On what ground? Please refer. I was like, fine. Now you are going contradicting yourself. Please come to the court now. And that's why I said. And then whenever you send a legal representation, This is called speed. You send it by Indian Speed Post. Always preserve this. See, sender's name Advocate Rahul Tiwari over here, Under Secretary of Bar Council of India, Governor West Bengal, Under Secretary UGC. Sender is Rahul Tiwari, Dean of IT Kharagpur. Sender is Rahul Tiwari. You have to save this because this will act as an evidence that you have sent a legal representative and you have not just approached the court. You have first informed that, but when they did not protected your fundamental right and when they did not enforce your fundamental right, only then you have approached the court. Okay. Now, have you understood? My right to education and my right to take admission in government institution was getting violated. Not only I secured it, I mean, not for myself this time around, okay, but at least from now on, they cannot deny admission to anyone who has got 1 year LLM degree. Are you getting it now? So whenever in future, if you want to take admission in PhD, just see their brochure and you will find it will be written 1 year program and 2 year program. And that is how you BC and drafting part also. I will share you my writ also, or draft of my writ, so you can see what all things has to be there. Because in the writ petition, in the court, you have just I made a writ petition of all with including all the judgments and action. It was 150-page writ petition. How much time I get in the court? 2 to 3 minutes. You have to first convince the court that whether my case is maintainable or not. Issue number 1 is always on the maintainability. Then the issue number 2 starts with your fundamental rights, whether my right is getting violated or not. Okay, my case got admitted. The judge felt that yes, the case has got merit to be heard, and then the notice was issued. Okay, that is how your fundamental rights get violated. First, send the legal representation. Okay, then approach the court. According to the appropriate, I'll share you few example of CNLU and DU also. Okay, and then IIT part is covered. This is covered. This is covered, and then I'll start. I'll share few other examples and few technical aspects also. Okay, regarding the res judicata and whether the conscious, even if and I'll dictate you few judgments that if there is an alternate remedy, what should be done, all these things. And I'll share you a particular case where a woman was wrongly charged with SC/ST Act. I filed a quashing petition and also a writ. Okay, and I had to convince I was able to convince the court that she just abused, so only section 509 is applicable, that abusing a woman, but not SC/ST provision is not, it cannot be entertained in this particular complaint. But anyway, that part comes later. There was someone who has raised the hand. I'll take a small break of 2 minutes now to take questions. So as of now, if you have any questions, please ask. There was a person who has raised the hand. And no, don't ask like this. Or just wait. First is Chavi. How can I see raising hand? Now I have raised hand. Okay. How do I see who all people have raised their hands? First is the Chavi, right? Can you clarify? We can use. Okay. Yes. Please ask your doubt.
Good evening, sir. Good afternoon,
Good
sir.
evening. And just Chavi, just a second. Chavi Kakran, my name is again Advocate Rahul Tiwari. I'll request everyone to do connect with me on LinkedIn. Okay, there you can see I've got close to 34,000 followers over there, and also that is one of the best professional platform where I have acquired most of my clients and most of my work roles. Okay, so yes, please, Chavi, please ask your doubt.
So what about internship program? In most of the internship program, they prefer a 2-year LLM course instead of 1 year.
Which internship program?
So most of the internship I seen they prefer 2-year LLM.
Government institute. Government institute?
No, sir, private.
No, I don't think so. But anyway, you send me the detail. I'll send the representation, and I'm not going to charge any cost. Don't worry on that part. I'll send the representation. They will then they will change it automatically. Don't worry.
Okay, sir.
Okay.
Thank you.
Okay. Yes. Yes. Second. Next. There was someone. Menka Gandhi with me. Yes. Sir, name. Please give the name of the case. Exception of defamation. Okay. Can you clarify where we can use mandament? Like your example, mandamus. If you're filing a case against a where or writ petition is filed where the cause of action has been arised. In my case, I had to go to the Calcutta. Why? Because IIT Kharagpur is in West Bengal. Okay, Hassan. Next. There was one more person who has raised the hand.
Sakshi,
Any other
please,
doubts?
please unmute your mic and ask your question.
Yes, Sakshi.
Very good afternoon, sir. I am
Good
student
afternoon,
of
Sakshi.
BLLB. I am
Mhm.
student of BLLB in first year now. But the
Mhm.
problem which I am facing is not regarding this, but it's different. But as you are elder to me and senior to me, can you guide me regarding this? The concern is about in our college, as our SAM was started from last of the August, last year's
Mhm.
August, and we
Mhm.
give the complaint regarding the water because water resources are not providing in our department, and then they
Mhm.
put one of the RO machine, and rather than that the mineral water resources, but that all are getting collected from the washroom tap, and that was in front of the eyewitness of all of our students. So
Do you
we
have the recordings? Do you have the recordings, Sakshi Jangir?
No, sir, we don't have recording because we just went for to the dean's office and then we raised this concern to them. And then
First,
we give.
file a complaint in the municipality. Straight away file a complaint in the municipality and causing public disorder yes, causing public inconvenience, file a criminal complaint in the nearest police station under section 279 IPC.
And second thing,
Okay.
sir, we also given our dean a written letter and application regarding this complaint, and it has been now
Mhm.
4 months, and the complaint is being due only. Or if we go to the dean regarding any of our normal concerns also regarding our academics and anything, they just behave so much rude to all of the students of us, and they just concern like if you don't do this you will feel you will get the difficulties in your exams, etc., etc. They literally said this, and even in our official groups also they just mentions the messages that you need to compulsory come in that seminar, webinar, etc., and etc.
No,
And if
no,
you
that
don't
is
come.
something else. See, coming to seminar, webinar part, that it cannot be changed in India. But regarding the water problem, no, I've given you the solution. Okay.
But sir,
So
now the
file.
last one more question,
Yes.
sir. The last judgment which our respected Supreme Court given us about regarding the regarding the uh, presence and absence of the
You
ratio.
can say it in Hindi. Don't worry. Don't
ओके
worry. आप
सॉरी।
हिंदी में बोल लीजिए.
हाँ, तो वो जो कंसर्न
बताइए.
था वो हाँ, तो वो जो कंसर्न था वो इस हिसाब से था कि हमारा जो प्रेजेंट एब्सेंट रेशियो है वो बहुत कम है, बट रिगार्डिंग दैट आई ऑलरेडी शोन देम कि मेरी जितनी भी फाइल्स
अटेंडेंस का.
थी, रिपोर्ट,
अटेंडेंस
हाँ
का.
अटेंडेंस के लिए, हाँ तो मेरी जितनी भी
हम्म.
रिपोर्ट्स थी, फाइल्स थी, सोनोग्राफी थी, लाइक रीसेंट ऑल्सो, तो वो सब मैंने उनको शो करी, सब कुछ बताई कि आई हैव अ सीरियस प्रॉब्लम ऑफ माई हेल्थ एंड दैट वाई आई डोंट कम, क्योंकि मेरी जो कॉलेज है वो यहाँ से अप्रोक्स 30 किलोमीटर दूर है और इट्स ऑन हाईवे, तो मुझे पूरा ड्राइव करके जाना पड़ता है। और उसके भी रिगार्डिंग वहां पे दो बार तो मेरे एक्सीडेंट हो चुके हैं एंड इट्स नॉट अ सेफ प्लेस। और अगर कुछ इम्पोर्टेंट नहीं होता है तो मैं नहीं जाऊं तो इट्स ओके इन माय अंडरस्टैंडिंग। तो अगर मैं जा भी रही हूँ, लाइक मैंने कंटिन्यू जाना स्टार्ट किया पर वहां कोई क्लासेस नहीं हो रही थी, कुछ नहीं हो रहा था। देन आई आस्क्ड टू अवर फैकल्टी मेंबर्स के आप बता दीजिए कि जब आप क्लास रखोगे तब हम आएंगे, तो भी उन्होंने बताया नहीं। और अब ऑल ऑफ अवर फैकल्टीज डीन एंड दे आर जस्ट बीइंग लाइक के आपको ये फेस करना पड़ेगा, ये एक्सेट्रा एक्सेट्रा। और मैंने मेरा सीरियस रीजन जो भी है, मेडिकल इशू जो भी है, वो भी प्लेस किया, देन ऑल्सो दे आर इग्नोरिंग इट एंड जस्ट पॉइंटिंग आउट के दैट यू नीड टू face difficulties in the exam. But sir, I topped in my all semester exams of the first year. Now the final exam is going to come and in further एग्जाम्स मैंने सब में टॉप किया है, मेरे सब में फुल मार्क्स है, लाइक ऑल ऑफ द इवन इन लैंग्वेज सब्जेक्ट आई स्कोर्ड A+, बट नाउ these deans are getting so much rude of me and
No,
when I
no.
say
I Sakshi have to cut short. See, देखो ये वाली प्रॉब्लम जो है ना, ये तो सब जगह आती है, ठीक है? ये हर एक जगह आती है साक्षी, इसमें कोई वो वैसी बात नहीं है। बट रिगार्डिंग जो आपके एक जो सीरियस कंसर्न जो मैंने सुना अभी तक, वो आपके
हाँ,
जो वाटर प्रॉब्लम वाला था, विच इज क्वाइट सीरियस, एंड आई वुड से दैट आई हैव गिवन यू अ प्रॉपर सॉल्यूशन आल्सो, दैट इट विल बी बेटर। आप सबसे पहले आप म्युनिसिपैलिटी में कंप्लेंट करिए, so that
sir,
an
1 second,
inspection
can
can
I
take place.
note it? Sir, can you dictate it once again so I note it down?
Now please file a complaint in municipality. Simple. उससे काफी कुछ हो जाएगा.
Okay, sir. Thank you, sir.
Okay?
Thank you, sir.
Yes.
Thank you so much.
Okay. Next question. Hassan, yes.
Hello, sir.
Hassan,
Can you
yes,
hear me?
please. Yes, hello. Yes, I can hear you.
Hello, sir. So my thing is that regarding a university evaluation. Okay, so I recently joined law. I'm in second semester right now. So during my first semester results, okay. So basically, my college is affiliated to KSLU, Karnataka State Law University, and all the evaluation of the semester exams have been done there, not by our college. So first semester, in one of the subjects, I got 25 marks out of 100. And when I applied for reval, paying 500 rupees as a reval fees, I got 60 marks. And when I asked for a refund, because there is clearly no mistake done by me, it's completely like the mistake of the university valuation. Okay. So when I asked for a revaluation from the college, and they're like, there is no revaluation provided for the normal revaluation. Actually, there are two types of valuation. One is normal
I got it.
revaluation.
In this part, you can first send the legal notice to the dean. Okay, you can send the legal notice to the dean that the KL, your college is private or government institution? Because KSLU, I know it is government.
Yeah, it is affiliated to KSLU. My college is
but
affiliated
the
to
college
KSLU.
is private. The college,
Yeah.
but the college is private.
Yeah.
Okay, and who conducts the revaluation? KLSLU or your college?
KSLU itself. All the
KSLU,
things have been done
KSLU
by
conducts,
KSLU.
and all the rules are being made by
Yes,
KSLU, na?
KSLU. Yes, absolutely.
Okay. Send the representation. Okay, send the representation straight away to the dean, and a copy. First of all, send the representation to the controller of examination of KSLU. Then send a copy to the dean, and again the copy to the governor of Karnataka. I think that will be more than enough. But it has to be sent by an advocate. So if you have any advocate in your known, take help of it. Okay, but send the
my question is,
representation first. Yes.
okay, but my thing is that I want to change their policy itself, because if a student is getting
But
higher
for
marks
I
than what,
understand, I know. But for that you have to send the representation, na? You have to send the representation. Even if you wish to challenge before the Karnataka High Court. Your college is in which degree? Oh, district.
Bangalore urban.
Bangalore. Urban. No. And KSLU main campus is in
Hubli.
Hubli, no? So the case will be filed in the Hubli bench because if I remember, I know that Bangalore have got three benches. One is in Hubli, one is in Bangalore, and one it is in I'm not getting it. Somewhere one is in Dharwad, which is the twin city of Hubli, and one is in Kalaburgi. The third bench is in Kalaburgi, right?
I'm
So
not
your
sure.
case will be, yes, I'm telling you, it's in Kalaburgi, okay? And your case, it will be filed in the Hubli, okay? And in in Dharwad bench, and in Dharwad bench also, I'm sure online hearing takes place, okay?
Okay, sir. Thank you.
And we are do connect on LinkedIn also. Yes, next question and last, basically, and after that, I'll continue with my webinar. And I hope, first of all, please give a small feedback. You guys are in the at least in chats and in the thumbs up. You guys have enjoyed up till now. I've given you the theoretical and the practical aspects as well. Everyone, I hope you all have enjoyed the webinar. You have learned something new, not just a basic theoretical exchange of knowledge where a person comes and share his knowledge or insight, I guess. Okay. So last question. Anyone? Any doubt up till now?
If anyone has any question, please raise your hand.
Question in appeal and writ. What is the difference between question of law and substantive? It's the same thing. See, question of law means what right is being violated. If it is a fundamental right, or question of law means it basically decides. Question of law, like if you are filing an appeal, then on what ground? On what ground you are filing an appeal? What law or what violation or what part you feel that it has been not touched? And like in my writ petition, the question of law is right that whether a 1 year LLM degree is eligible to take admission or not. Like if I had an executive LLM, I'm not eligible. But if I have a regular LLM, I am eligible. I'll give you another example. CNLU. I'll see. I had written. I had sent a legal representation there also. So what happened? That there are various departments in the government of Bihar, like government department of excise, department of health. So they always take legal researcher or legal consultant on contractual basis. Okay. So, and a writ petition has been filed also, and even after filing and even after getting a stay, in the next notification, they have done the same thing. But I'm just giving you, for example, that how one of my colleague has used it and how I basically entered and I ensured that they changed the criteria little bit. So what happened? In the notification, CNLU said that all the UG law graduates, means who have done their BLLB from CNLU, they are eligible for interview of a legal consultant in excise department of Bihar. Okay. So I sent a legal representation asking the excise department that why the postgraduate and the PhD scholar or PhD pass out of CNLU are not eligible for exam for your legal consultant post. Like for example, if someone has done LLB from Magad University and he is pursuing LLM from CNLU Patna, why he is not eligible and why only exclusive right to interview is given to CNLU student. So in their subsequent notification, they said that if a person has completed the post-graduation and PhD from CNLU, then he's eligible. I was like, fine. Already, what happened in this case, there was a person who has completed his LLB from DU. which is a prestigious university. The Faculty of Law, Delhi University, has given so many Chief Justice of India, Chief Justice of Delhi High Court. So he completed his LLB from DU, and he was a LLM law student. He has completed his LLB degree from Faculty of Law, Delhi University, and he is practicing in before Patna High Court. So when he came across this notification, he wanted to apply, but there was no scope as the exclusive right was given to the CNLE student. So he filed a writ petition challenging that it is violating Article 16 and Article 14. Article 14, right to equality, and Article 16, equal opportunity for everyone for public employment. Excise Department is a government institution, and government institution is, if the government institution is not giving equal opportunity to everyone, it is violating the fundamental right. The notification was stayed. But again, when they gave a new notification, they had the same criteria. But I wanted to challenge it, but I left it that I cannot go to. Although I'm from Bihar, but it was become very, and I'm settled in Gurugram. But it was very tedious for me to travel to and fro for this particular case. IIT case, I did it because I wanted to take admission. But this I left it, and again, the case has been stayed, and I hope that Patna High Court gives give this judgment that all the now graduates from anywhere in India, they are eligible for the legal consultant post. Now, I have written whenever you draft your legal representation, I have written, the Wednesbury principle. So what is this Wednesbury principle? See, it originated from UK basically. So there was a criteria. So there was a criteria in UK that, I mean, they had fulfilled a criteria for a job which was very. I am hearing a lot of voice from the background, and request everyone to please mute yourself. Student. Shreya, please mute yourself. Varun, please remove.
Done, sir.
Please, I can still hear it. Please remove him. Please remove her. Okay. Now, so when the case was filed in the UK court, it said that one cannot, and it was written it is used as Wednesbury principle, that one cannot create criteria which enforcement is difficult. Means one cannot create rules and regulation which is difficult for everyone to enforce. So the conditions should be in a manner that everyone can follow it, and it can be enforced on everyone. Okay. Now, this particular principle is used, and whenever you draft a representation to enforce your fundamental right, you have to use, and it actually creates more weight for your representation and for your representation, this Wednesbury principle. Okay. Now, moving forward, there was another case in the Delhi University where the students has filed, because Delhi University has an interesting criteria. Delhi University has also got two types of LLM. 2 years LLM degree and 3 years LLM degree also. Means 3 years LLM degree, regular LLM degree, they have got permission also. It is for working principle. And for 2 years LLM degree, they take it in writing that if you are pursuing 2 years LLM degree, then you cannot practice during those 2 years period. This again was challenged before the Honorable Delhi High Court, and the Delhi High Court said that no, and a person becomes a lawyer after completing his LLB, and he becomes an advocate once he enrolled in the bar council. That's the difference between a lawyer and an advocate, right? When he becomes an advocate, his experience starts, and it is not necessary that he has to appear before the court. He can appear before the court when the classes are not taking place, and he can give the legal advice. So, if they are creating a condition, Wednesbury principle again, that if they are creating a condition that if you are taken admission in 2 years LLM degree and You are creating a condition that you have taken an admission 2 years and you cannot practice. Then what is it violating? Your right to employment. Your Article 21 is getting violated. Means other people who are pursuing their LLM, when the classes are not taking place during semester break, they can appear before the court, but DU students cannot appear. It was challenged, and that particular condition was quashed. That is how you use your writ petition to enforce. If your fundamental rights are being not enforced, you can compel the authorities and to protect your fundamental rights. Okay. Now there is an interesting criteria which now I'm going to file very soon within either this year or in coming years. I had filed that. What happened that in judicial service of Jammu Kashmir, when they gave a notification that you are eligible to take admission for judicial service. So when I read the criteria, and that too after the abrogation of Article 370, the Article 370 is that they said that every person is eligible who is either the residents of Jammu Kashmir, means a domicile, the person should be a domicile of Jammu Kashmir on for 15 years, only then he is eligible. I was like, then what was the purpose of abrogating Article 370? फिर हटाया क्यों 370? जब remaining part of Indians cannot take government employment. So I sent the legal representative and I got a very funny reply that we can create a condition as per Article 16 of Indian Constitution. I was like, no, bro, it cannot. Then I filed an RTI again that our non-domicile residents or citizen of India can take public employment in Jammu Kashmir or not, and they said we don't have any clarification. The reply which I received was that we don't have any clarification. I was like, fine. Now I have got a good. And if any one of you wish to file a writ petition, no issues. If they file before me, no issues. But now this is I have in mind. Why? Because I have got my whether using Maratha reservation policy or everything, that one cannot have 100% reservation for any particular state or any residence or a domicile person of any particular state. One cannot have 100% reservation. So I was like, fine, ready. I'm just waiting. See, I can file again, but again, now I'll come to the practical aspect of the court. It is quite uneasy. It will become very uneasy for the judges also to admit my writ, because they'll say that this notification came last year, you are coming this year. What were you doing? Already the limitation has passed and everything. I'm dismissing it. Although I'll make news, but does not mean. But I will not get any relief, so I'm not filing as of now. Once any notification will come for public employment, whether for public prosecutor, for judicial officer, or for Jammu Kashmir Public Service Commission for SDM DSP selection, no? They will have this criteria again. I'm 100% sure that should be a domicile of Jammu Kashmir, and that for that domicile also he should be living in Jammu Kashmir for 15 years. Only then he's eligible. I was like, fine, now come to the High Court. Okay. And I've already contacted the local council in Jammu Kashmir also. Okay, that I'm going to file the case. So be prepared that I'll be needing your ground support. Means the filing part, sending summons part, and everything. Now, IT. This was my writ. How you draft it? The best way is see this. I hope this is screen has been shared. In the High Court of West Bengal, Calcutta, writ petition. It is civil writ petition. See, I highlighted it. Rahul Tiwari, petitioner. Yes. List of documents. Relevant document. This is the memo of the parties. And then it starts with this. It's not showing on the screen, is it? Yes, it is showing now. List of date and events. First, you have to write the list of date and events. First date of list of events, when the advertisement came up. Then when I sent them an email, I didn't get any reply. Then the reply which I got, a strict no. Then when I sent them a legal notice, they received the legal notice, and then there was a problem in my representation. Then I sent them a correct representation. Reply. When after waiting for like 10 days, when they didn't give me any reply, even if when I sent them the correct representation. Okay, when I send the, just wait, let me. When I am cutting the call, still they're calling again and again. Don't worry. Now, last part, hence the writ petition under Article 16. Article 226 stated. Just give me 1 minute. Am I audible now? Everyone?
Yes, sir. Yes, sir.
And it is also an interesting part of life that when you don't want anyone to call you, everyone calls you at that time only. And then the writ petition and see. First, this is the second most important thing. First is the list of date and events where you can write everything that what happened and why you are approaching the court. And then this part, synopsis, where you have to combine your list of date and events and you have to send a small synopsis. Judges के पास या उनके researchers के पास इतना time नहीं रहता है कि they will read your entire case. They will just read your synopsis to understand whether this case is maintainable or not. And on the first date of hearing, once you file the case, the file is taken up by the court. You are lucky that the judge has allotted you time. In the brief synopsis, you have to explain this has happened. My fundamental, this is what I did. My fundamental is getting violated. My lordship, please issue notice. And once the issue notice is done, send a copy to every party. Or you can send the before that. If the case file is taken up, you can say that I've sent the copy to everyone also. Okay, this part, synopsis. And then once the case has been admitted, then you said in detail what were the brief facts, the annexures, and then say UGC partner, a degree equivalent to any of the above, which I was clarifying. And then on what grounds you'll tell the grounds that I have, on what ground I should be admitted, and then the judgments that our court has given the right to meritorious. See, Saurabh Chaudhary versus Union of India Supreme Court, way back in 2023, Honorable Supreme Court has clearly given the status that basic right of a meritorious student to get admission to a better institution is my fundamental right. This is my getting violated. Okay, and your framing policy, the Supreme Court has clearly said that it should not be arbitrary. A participant has clearly written about the Menka Gandhi's case. What was there in the Menka Gandhi's case? That any policy, it cannot be arbitrary in nature. It cannot be unreasonable in nature, and it should be just. The policy should be just The policy should be fair, and the policy should be just, fair, and reasonable. It should not be unreasonable, and it should not be arbitrary that you have made any policy to enforce on everyone. See, this is judgment, and then the last, your prayer, and then your annexure stuff. List of documents. This is basically my draft. I cannot share my entire PL with you. Okay, stop sharing. So I hope you have understood this particular point. Okay, the basic writ petition, you have to identify your fundamental right is getting violated. On this is ground, send the representation, save the that report, postal receipt. It will act that the representation has been received and no action has been taken the ground, and hence you are approaching the honorable court to enforce your fundamental right. Now, Varsha Dubey sir, my question is that court proceeding go faster और more affordable बनाने के लिए क्या क्या reforms की जरूरत है? For this, I'll be needing 3-4 webinars. A lot. First of all, biggest thing, not the infrastructure or anything. First, at least triple the judges. Only then proceeding will take faster. Even if the AI is not available, even if AI is not there, or even if the digitalization of the court is not taking place, does not matter. Increase the number of judges. For me, that is the only way you can make the proceedings faster. So I hope the basic, the drafting, filing, and the writ petition part is clear. Now, please make a small note of it. The principle of res judicata in the writ petition. Now, what is res judicata? On same question of law, listen to me very carefully. On same question of law, between the same parties, if they filed in the same court, and if the case is heard and it is decided, you cannot file the case again. So, for example, IIT Kharagpur case, I have filed the case has been heard and it has been decided. Then I cannot file a case again in the Calcutta High Court. For that, I have to wait for another either notification, then I can file the case. Okay, but if the case has been decided by Calcutta High Court, I cannot file the case again. That is the principle of res judicata. But remember this thing. Remember this thing. The res judicata is, please make a note of it. The res judicata, the principle of res judicata is not applicable on the writ of habeas corpus. Okay, please. And it was held. Please write down the name of the judgment also. Please, इनका video बंद करिए. Actually, please turn off your video. P. Bandopadhyaya. In the case of P. Bandopadhyaya versus Union of India 2019, it was held that principle of res judicata is applicable on writs. Okay, everyone has written. Now, what does it mean? You have filed a writ petition. The court has heard and the court has dismissed your writ petition. High Court has filed a writ. You have filed a writ petition in the High Court. The court has dismissed. Then what you can do? Against the dismissal, please write down. Against the dismissal of writ petition by High Court, you can file SLP. Because आपने केस फाइल किया हाई कोर्ट में, वो डिसमिस हो गया, तो आप उसके अगेंस्ट अगर आप जाना चाहते हैं तो आप SLP फाइल करेंगे, ना कि एक नया रिट पिटिशन फाइल करेंगे. See, writ petition, High Court has already decided. Okay, the High Court, like suppose karo, in my case, in IIT's case, suppose the case was dismissed on merits. Then I cannot file another writ petition under Article 32 before Supreme Court. In that case, what I have to do? I have to file an SLP under Article 136 of Indian Constitution. Is this part is clear or not? Yes or no? Understood, everyone? Writ petition gets dismissed, you file SLP. You will not file the writ petition again. Is this part clear? Everyone? Is there any doubt? Now write 3 other judgments. Magad Sugar and Energy Limited, Magad Sugar and Energy Limited versus State of Bihar. Second judgment, Godrej Sara, SARA, Sara. This is second word. The third word is Lee. Godrej Sara Lee Limited versus Excise and Taxation Officer. The Magad Sugar was a 2021 judgment Supreme Court. Magad Sugar के आगे लिख दो 2021 Supreme Court. And the second judgment is Godrej Sara Lee versus Excise and Taxation Officer 2023 Supreme Court. Okay. Third judgment, Maharashtra State Board of Waqf. Maharashtra State Board of Waqf versus Sheikh Yusuf Bhai Chawla versus Sheikh Yusuf Bhai Chawla, 2022 Supreme Court. In these three judgments, they had one common ratio which was given by the court. And what was that ratio? In these three judgments, right? In these three judgments, it was held by the Supreme Court. It was held by the Supreme Court that even if there is an alternate remedy available, even if there is an alternate remedy available, the writ petition, the person can still file the writ petition. The person can still file the writ petition. Is this thing clear or not? Means if you have filed a writ petition and the opposite party said that this person is wasting time of the court, he should have filed this petition, the remedy was available. No. Even if in that way, the party has the right to file a writ petition. This part is clear or not, everyone? Understood? Everyone give me thumbs up. Understood now? Because I'm going to dictate you one more judgment. So in this part you have read in this webinar, everything is covered. Your class has been covered, knowledge sharing is covered, practical insight is covered, drafting is covered, as well as your making notes is also covered. Okay? Now, write down this judgment. In the case of Kapil Agarwal versus Sanjay Sharma. Kapil Agarwal versus Sanjay Sharma, Supreme Court. It was held that if the FIR is lodged, and there is an abuse of power, a writ petition can also be filed. A writ petition can also be filed to quash the FIR. Okay? So quashing के लिए जरूरी नहीं कि आप 482 CRPC या 528 BNSS में ही जाएं. You can file a writ petition also. And same thing I used in this SC/ST Act. Okay, where the case was that there was a dispute between a landlord and a tenant. The landlord was able to secure the removal of the tenant from her property, but the tenant had some grudges, so they fought over a phone call. And the tenant was smart enough that she was, both of them were women. Okay, so the tenant was recording everything, and she was there with her advocate also. The advocate belonged to the SC/ST community. So while there was an exchange of words, sir, they were abusing very badly. And then when she said something like she used the word chamar and ye hai, wo hai. So by the time she gave the phone, so phone was on speaker, she gave the phone to her advocate. Her advocate listened. The recording was taking place. On that recording, they filed an ST/ST FIR. The client secured bail also from the Saket court. And when I filed the quashing along with the writ, I found a good judgment where I established that to constitute an FIR or an offense against ST/ST Act, Under section 2, the offense should have taken in a public place. And here it happened over a phone call, and the accused was unaware that the person who is listening to the phone call, whether the person belonged to the SCST category or not. And Justice Sanjeev Narula, thankfully, he was able to convince himself, and he said that yes, the offense is not clearly made out for ST offense, but yes, the offense is made out for abusing a woman under section 509 of IPC, only 1 year imprisonment. Okay, but I will require the reply of the state also. So this is how you are able, when you have complete knowledge, when you are diligent enough for the research, you are able to secure justice for your client through the way of law. So that was the part of my webinar, and I'll rest here. Okay, I'm available on LinkedIn also. So anyone, and I hope beneficial to do forensic lab. Yes, Vaibhav, it will be. Harshita, no. Res judicata is not applicable on habeas corpus. Vaibhav, it will definitely help you. Okay, such internship, and I will request you can share feedbacks and thumbs up feedbacks on the chat box, that whether you enjoyed this webinar or not, and do connect with me on LinkedIn. And I hope in this webinar you have learned. I can still see that apart from me, Varun